Ma'am, are you Almeida Miles? Yes. And Miss Miles, the best you can, raise your right hand, please, ma'am. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Yes. All right, you can put your hand down. And Miss Holmes, will your client waive the formal reading of the motion?
Yes, Your Honor.
Ms. Miles, in cause number 24, DCCR 2330, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation September 16th of 2025 for the offense of tampering, fabricating with physical evidence, a third-degree felony, and that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
The motion alleges you violated your probation. Count 1 alleges that you failed to.
Some of them are kind of redundant.
Okay, well, we'll start with this one, then we'll see. So count 1 alleges that you failed to avoid injurious or vicious habits, in that you physically assaulted another offender in the B3 pod on or about the 6th day of November 2025 at the Henley unit, which is the ISF unit. Is that true or not true?
True.
Count 2 alleges that you failed to complete the education program, the GED program, because you stated that you were tired and did not feel like going to school so early in the morning every day. Is that true or not true?
Yes.
True or not true? Sounds ridiculous when you hear it read back to you, doesn't it?
Yes.
Count 3 alleges that you failed to enter and successfully complete the ISF program, and that you were removed based on behavioral issues. Is that true or not true?
Sure.
Count 4, well, it's different. Count 4 alleges that you failed to comply with all of the directions of the ISF program and that you engaged in sexual misconduct while participating at the Henley Unit ISF. Is that true or not true? And then count 5 alleges that you failed to comply with all of the directives of the ISF program and that you were walking around in the, quote, living area of the dorm during count time against the rules. And that's also at the Henley unit. Is that true or not true? That one's not true. So did you enter your pleas of true to counts 1 through 4 freely and voluntarily?
Yes.
And did you plead true to those counts because they're actually true?
Yes.
All right, then I'm going to find that you entered your pleas of true to counts 1 through 4 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation. What I would like to do, I'm going to reset it. I don't know that I need, because she really hasn't been out, a full update, but I would like as much information as we can get from ISF. So if they have reports that you guys can get your hands on so that I can read more about what went on there, that will help me, I think, with sentencing. Anything that you think is important for me to know, Ms. Holmes will be out there to visit with you. Tell her all of that. She'll present it to me on your behalf when we come back for sentencing, and then I'll decide what to do.
Yes.
All right, you can go back with the bailiff. Oh, wait, come back for a second. So, Ms. Miles, I do want to make sure you understand, obviously, it's important how you behave when you're in custody. And so anything that happens between now and when you come back for sentencing in our jail is only going to make things worse. So my suggestion is you better get out there, you better lay low, and you better follow all of the rules, because anything that I might be thinking about doing is going to go up in years if you're out there misbehaving. Okay, go back with the bailiff. Let's see, Eric Wara, Ms. Holmes.
It's signature.
Hubert. Okay.
Good morning. Are you Isaiah Cheatham?
Yes, Your Honor.
And Mr. Lewis, will your client waive the formal reading of the motion?
He does, Judge.
Mr. Cheatham, in cause number 22-40220, I have a motion to revoke your unadjudicated probation. This shows that you were placed on probation June 6th of 2023 for the offense of assault family violence, a third degree, and that was a 4-year deferred probation. Is that correct?
True, Your Honor.
Is it correct?
Yes, ma'am.
Okay. Now comes the true or not true. Count 1 alleges that you violated your probation by committing the new offense of conspiring to transport illegal aliens April 8th of 2024 in Kinney County, Texas. And is that true or not true?
True.
Count 2 alleges that you failed to remain in Jefferson County as ordered and that you were in Bracketville, Kinney County, Texas, without permission April 8th of 2024. And is that true or not true?
True.
Count 3 alleges that you provided a urine sample February 29th of 2024 that tested positive for marijuana. Is that true or not true?
True.
Your Honor, the state would elect to abandon the remaining counts or allegations.
State abandons 4 through 8. Is that correct?
Yes, Judge.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
Yes, Your Honor.
And did you plead true to those counts because they're actually true?
Yes, Your Honor.
All right, I have some documents here on the tablet that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, Your Honor.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, Your Honor.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Cheatham is not competent?
No.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time, find you guilty of the third-degree felony offense of assault family violence. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. Right? Good luck to you, sir. You can go back with it. Yes, sir.
Your Honor, given the nature of the plea, I just wanted to say what the state's is withdrawing its motion as it relates to the treatment of the jail staff. I mean, I filed a similar motion.
I'm sorry.
In light of the nature of the plea, I'm withdrawing my motion that I filed about the treatment of the jail staff.
Oh, okay.
It was a similar motion to the other case.
Okay. So, Mr. Cheatham, you've only got a short amount of time left, probably here in Jefferson County, and you'll catch change and go to TDC. It's important that you understand that if you continue to behave the way you have behaved in our jail, you're not likely to make parole very soon. So on a 5-year sentence, you could be eligible for parole in a year and a half or so. So it's up to you. Get there, act better than you've been acting here. Maybe you'll get out on that parole. You keep acting like you've been acting in our jail, you're likely to do that whole 5 years. That's going to be up to you. You understand?
Yes, Your Honor.
All right, go back with the bailiff. Mr. Lewis, you have Derek Corbin.
Do we need Corbin?
Corbin. There you go. Good morning. Are you Jonah Johnson?
Yes, ma'am.
This is 25 DCCR 1775. Mr. Johnson, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon, and that's from August 31st of 2025. And what that means, sir, is if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand?
Yes.
Can you check if there's any of his in that pile? I have here on the tablet a plea bargain rejection that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 15-year term in prison You have every right to reject that, have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to plead guilty. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we'll get that done. Mr. Johnson, Ms. Holmes has been appointed to represent you, and she's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release her and appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? All right, so Ms. Holmes, you are released. Mr. Johnson, we will appoint someone today. They should be out to the jail very soon to begin preparation for trial. All right?
Yes, ma'am.
And there's none. And just because I get on to everybody for having incident reports, thank you for not having any incident reports. I mean, right? I feel like I need to, seriously though, it can affect your case. It can affect how the DAs look at your case. It can affect how a jury looks at your case. Continue doing what you're doing in jail, following the rules, because that's only going to benefit you, okay?
Yes, ma'am.
All right, you can go back with the bailiff. It just can't be negative, but gotta do something positive.
Yeah.
Let's see, you've got Almeda Miles.
Yes. So we talked about what to do next.
Okay, well, let's just get her out here and we'll
Okay.
figure it out. Documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Ms. Holmes?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Juarez is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of the second-degree felony offense of aggravated assault with a deadly weapon. Sentence you in accordance with that agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will be an affirmative finding of a deadly weapon in this case. I am handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, good luck to you, sir. You can go back with the bailiff. Hey, Ms. Holmes, you've got a sentencing on John Dre Willis.
Yes.
Willis. 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 Willis.
Good morning, sir. Are you John Dre Willis? This is cause number 25 DCCR 1048. Mr. Willis was previously in court, entered a plea of guilty to burglary of a habitation. I've received the pre-sentence report. Have you both had an opportunity to review that report?
Yes, Your Honor.
I have, Judge, and in light of the fact of the Louisiana murder
Yeah.
case, I knew the PSI
That's-
came in a tad bit late due to no fault of her own. Miss Carvin had a death in the family, so I would like the opportunity. It seems silly to put him on probation, and he has a hold on that.
So, just for clarification, he's not the suspect. There
Okay.
actually has been someone else indicted for that case. He's
Okay.
a witness that they're holding. So he's not the defendant in the murder
Okay,
case.
it just reflected that.
Yeah,
he
they
had
do
been
have a
charged
hold.
with-
No, he's not charged with the murder,
Okay,
but he is a key witness in the murder.
okay. And they put their witnesses in custody?
That's what I was told.
I'm sorry?
Yeah, the detectives.
They,
They
yeah,
came to visit him,
they came
um,
here, okay.
so that's what I've been told.
Would you like me to confirm any?
I just,
Yeah,
not that I
yeah,
didn't
you
tell,
can.
other than through him, did you, that's just what your defendant, which, and I'm not saying I don't believe you.
Yeah, that's what has been relayed to me.
Okay, so
So-
let's do this. Sorry, let's, I don't know if you can
I can reach out to Cal.
reach out now and see if you can make
Okay.
sure of that this morning. We can go ahead and go forward this morning. If for
Okay.
some reason you can't, we'll just reset it 1 week or something.
Okay.
So just have a seat wherever the bailiff wants you to, and we'll see if we can get that confirmed.
Okay.
Good morning. Are you Derek Corbin?
Mhm.
This is clause number 25, DCCR 1659. I'm going to take judicial notice of the court's file, Mr. Corbin's case. Mr. Corbin was evaluated for competency to stand trial by Dr. Rapon, received that report dated January 20th of 2026. And the finding in his report is that Mr. Corbin is currently competent to stand trial. Is there any other evidence with regard to competency, Mr. Lewis?
Not from the bench.
Mr. Nichols?
No, Your Honor.
Then at this time, based on that report, I will find that Mr. Corbin is competent to stand trial. He is charged with the offense of robbery. And Mr. Lewis, what is the announcement?
Judge, since we've gotten the evaluation back, Judge, I've been able to start one talk with Mr. Corbin, look at all the files. There is still some mental health issues that we're dealing with. I've gotten some records from his family that's come in here recently that I'm going through basic mitigating circumstances. But I do want an opportunity to talk about those with Mr. Nichols.
I'll just do a normal reset on Mr. Corbin's case. Mr. Corbin, I'm going to reset your case for about 3 or 4 weeks. Mr. Lewis will go through everything that your family's provided, talk with Mr. Nichols about that, and I'm sure he'll be out to visit with you about what your options are at that point. Okay? You can go back with the bailiff. The Caleb Jubert.
Okay.
I haven't seen him walk in. I know. It's definitely sick today. Just,